How's everyone today? My name is Chris West. I'm with Dalby Winland & Company, and we have a great crowd here today, almost 100 people, I think, that RSVP'd, another 100 online. So we're pleased to bring this conference to you, important information. Proud to be here with Auto Paychecks and bringing this information to you, and Michael Santo will be our guest speaker. This is impactful information, very important information to businesses in our state. So we are very happy to bring this to you this morning, and hopefully find significant value out of today's session. Again, we're, as Dalby Winland & Company, very proud to put this on. We thank you for being here. It's important for us as an accounting firm that, of course, deals with traditional compliance, tax returns, and audits and financials, which are very important things. We strive to push ourselves to be more advisory with our clients and help clients optimize their business and just be better in everything they do. And this is an example of that, trying to connect clients with important information that will help them be better. So again, thank you for being here. I'm going to introduce John with Auto Paychecks. John, I don't see you at the moment. Yep, you're over here. We're very thankful for Auto Paychecks. Auto Paychecks is a wonderful partner with us. As a 70-year-old accounting firm, you'd think we probably do our own payroll. We certainly have lots of talent and all kinds of CPAs and good people that can do payroll. We outsource our payroll to Auto Paychecks and have for quite a few years. And so we find Auto Paychecks a very valuable resource and professional in everything they do. John, I'll give you a few minutes.
Well, thank you for all coming today. Are you guys enjoying the sunshine this morning? Oh my gosh, am I grateful for wake up to a sunny sky. So I'm going to be brief here. I just want to thank Dalby Winland CPAs for coming together with us, and we thank you for their trust and their partnership. I want to thank Michael Santo for being here and being willing to share his expertise with us. We all know that there's a lot of changes coming to the state of Colorado with labor laws, and we're looking forward to getting up to date on that. Many of our clients are here. I want to welcome those clients and also those of Dalby that we haven't met yet. We'd love to meet you guys. Auto Paychecks, we started as a payroll company, and then over the years we've moved into what we call human capital management. So we have a single sign-on cloud-based system that'll help you manage payroll, timekeeping, human resources, benefits administration, COBRA administration, ACA compliance and reporting, as well as applicant search and onboarding. We're very proud to be in our 17th year of service to the Western Slope community. We have clients nationwide as well. And we'd be honored to talk to you and see if we might help you to be more efficient in your business practices. So thank you for being here today. There's several of our staff members. If our staff will wave, say hi. Several of our staff members are here today. And we would just, we would love to partner with you as we have with Dalby and hopefully help your business systems and practices be more efficient than they were in the past. So thank you, Chris. Appreciate it.
Just a few quick housekeeping things before we bring up Michael. Again, looks like we've got water and coffee over here. Feel free to help yourself. This session is being recorded today, so we will follow up with you. Those who are here in person, those online, we will follow up and to give you information and a link to the recorded session and the materials that you'll be seeing today. Online attendees can ask questions using the chat feature. You can chat with Sonia or Molly. Don't chat with me because I probably won't reply or not know how to reply. And we will try to address as many questions as we can before the end of the day. I know we have mics set up to ask questions of Michael here live. So with that, I want to bring up Michael Santo. Michael, there's a nice bio here, which I'll maybe hit a few pieces of it, but it says something about you being from Michigan, but that was probably a long time ago. And you and Betty Bechtel, started the firm way back when. That's Bechtel and Santo, now Bechtel, Santo and Severn, and has been an instrumental attorney practicing employment law on the Western Slope of Colorado and beyond. And we're just pleased to bring you here. You're a frequent lecturer on all employment law issues, and we're excited to bring you here on this very important topic today. Please join me in welcoming Michael Santo.
Thank you. Thanks. Good morning. So we're going to cover a bunch of topics today. So we're going to principally cover 3 issues today. By the way, if you have any questions, please shout them out. I don't have a defined Q&A period normally, so if you've got questions, they'll be coming in on the web. Just raise your hand and we'll address those questions. What are we going to cover today? Well, we're going to cover the Colorado Equal Pay Act. This was passed in last year's legislative session, is going into effect on January 1, 2021. Technically, though, you're kind of in the period now where you could be looking back to it, and we'll discuss the number of implications, particularly day-to-day issues with this act. We're going to discuss the Family Medical Leave Insurance Program. Who remembers this from last legislative term? This is our state paid FMLA program, covering all employers with 1 or more employees. So basically everybody. And this is going to be up this legislative session. We're going to just go over it quickly so you get a sense of what's happening. One of the reasons why it didn't really come to pass last term was because so many people got involved and got a hold of their senators and reps with respect to concerns they saw with the program. So we're going to go over that as well. And then the Colorado Overtime and Minimum Pay Standards, what we'll just be referring to as COMPS. This just came out last Wednesday, so I have to admit, I haven't memorized in 6 days everything, but I have read all of it. And so we're going to go through that. This makes a lot of changes to how you're going to handle paying employees day to day. So you ready? You guys are kind of quiet. We need like some caffeine or something. We're going to have crowd participation soon. Let's go over first the Equal Pay Act and what this is addressing in Colorado. This was Senate Bill 1985. The interesting thing about the Equal Pay Act is, frankly, in the United States, and we're still a part of the United States, in the United States, this has been the law with respect to discriminating with respect to compensation based on sex since 1964. So to a large extent, what this now law covers is not particularly new, but it's that day-to-day stuff that is really new and will really change how we compensate our employees and information we have to identify in doing that. I always get asked at the beginning, is there any chance we're not covered? Let me just start with no. We're all covered. We're all under this. You'll hear in COMPS that certain organizations are not covered, but every organization is covered into this. Nonprofit, 2 employees, 2,000 employees, you're covered. A lot of times I'll talk about salary, or I'll say, compensation or wage rate. Basically, when we look at this law and the requirements under the law, we're looking at the entire bucket of stuff. So that's salary, that's benefits, that's vacation, that's Applebee's gift cards, that's whatever else you may give employees, holiday bonuses at the end of the year. All that is covered by this law. It's not just salary. Good? Okay. It also covers part-time. It covers part-time, full-time, temporary, casual, PRN. It does not cover independent contractors, so we don't have to worry about that. But outside of that, it covers basically everyone who performs work for you who receives any compensation for doing that. First question always gets a prize. That's just the way it works. I said, raise your hand with questions. I threw it out there, but some people, So what are the requirements? Well, this whole long thing, an employer shall not discriminate by paying an employee of one sex a wage rate less than the wage rate paid to another. We're going to break that down into each of the requirements. One of the questions I frequently get asked, this is not just when we define sex, it is very broadly defined. So men can sue saying, hey, this female is paid more than I am. Females can sue saying this male is paid more than I am. Transgender status, sexual orientation, all get covered by that. So anyone who says, I'm paid differently than that sexual orientation or that gender, that can be covered under this as well. It's It's very broad. So what are our requirements? By paying an employee of one sex a wage rate less than the rate paid to an employee of a different sex. So we're looking at, in our compensation, are we treating individuals differently? And we'll see how we're going to establish that in a little bit. For substantially the same work. Well, how are we going to prove substantially the same work under this law? Any ideas? There you go. Job description. You don't get anything for the second. Sorry, it's just the first. Although first answer maybe should get something, but so job descriptions. Job descriptions, job descriptions, job descriptions. It is a key part of this law. When we're looking at how we're comparing individuals, what they're doing, the first place we're going to look is job descriptions. In fact, the law basically mandates that you have job descriptions. So if you don't have job descriptions, you've got 11 months and 3 days to get them in, because they need to be in for this law. Job descriptions, job description, job description. It's very important to make sure that you identify in those job descriptions what that person needs to do. For example, if they need to use certain computer programs, if they have to use Word, or if they have to use Excel, or if they have to use WordPerfect. Does anyone still use WordPerfect but me? There you go. You and we're the two of us. So we would have that in our organization's job descriptions. You want to make sure that those are accurate. I've had a number of litigations where we've been using the job description, and the employee in the litigation will say, well, yeah, but the problem is they're talking about this TPS report. I can always tell who saw the movie Office Space after I say that. But we haven't used that TPS report in like 7 years. Yet it still identifies that in my job description. Or you also get the situation where two employees change job duties. So we're not even aware as an organization that our employees aren't doing what they are supposed to be doing, or at least what we've put under that job description. So we need to make sure that the form of the job description is up to date and identifies what we expect that employee to do, and that it's substantively what the employee is also doing. So from that standpoint, breaking job descriptions down in terms of essential job functions, general job duties, those things all need to be in the job description. I would say be very expansive with job descriptions. It's a great case a couple of years ago where the organization was a credit company, and they had in their job description must deal with potentially abusive customers or creditors over the phone. And one of the employees said, I can't do this job. These two clients, these two creditors I'm calling all the time, they just yell and scream. They're so unhappy. And you have to take these two and move them to somebody else. Because I don't want to work with those two. It's too much stress for me. I need an accommodation. And the organization said, nope, you're required to do that. And then when the court addressed it, the court said, well, it's in the job description. Have to deal with unruly creditors. So if you have, I don't know if you have that situation, but if you have, think about those duties that individuals are performing, those things they have to perform, make sure they're in there. Regardless of job title. This will be key, things like I've been comparing, for example, an engineer 1 or an engineer 2 or a CPA 1, CPA 2. What are they doing that's substantively different? What duties do they have? What is an engineer 1 doing differently than an engineer 2? We need to establish that in our job descriptions. Because if they're in essence the same position, performing the same duties, we'll see later on why that's going to cause us a problem. Yes? That, great question. Did you look ahead? I went around and made sure people did. We will get to educational differences in a couple of slides, yeah, but that can be a distinction that's made. Based on a composite of skill and effort and responsibility. Again, we're looking back at day-to-day what these individuals are doing, how much responsibilities they have. That we are going to need to establish in these situation under this law that our differences in pay are not looking at individuals with the same skills, same effort, same responsibility. Someone who says, well, I work just as hard as the CEO, so I don't know why my pay is not the same. We want to make sure our job descriptions are identifying why that's different. Here's the big key in the law, and there's some practical things that we'll talk about day to day that you'll have to do as it's going along, but by far the biggest change in the law are these next couple of slides. And what they're based on is that for a number of years, when an organization would get sued, and I always use, for example, my organization, I claim, hey, Alicia's making more than me, and it's based on sex. What the organizations, particularly plaintiffs' attorneys, notice this is that, well, in one situation, the organization would claim it's all based upon how long someone's been here. And then the next time they'd sue, the organization would say, no, it's all based on how much, we like them. Then the next time they'd say, no, it's all based on attendance or some other factor. So what the law has done is it basically says you've got 6 distinctions. If it does not fit into one of these distinctions, it does not exist. It does not matter. And so we'll go through these in more detail, but a seniority system, merit system that measures quantity or measures earnings by quantity or quality of production. There was a lot of debate as to whether or not that last word should be performance, but it was kept production. Seems very, how many widgets does someone produce? How many billable hours does someone have? Seems to be very focused on that. Geographic location, education, training, or experience, or travel if travel is a necessary requirement of the job. If it's not in one of those 6, it can't be used. Do you have a question?
Geographic location because of cost of living differences.
That's what we think. We're going to go into each of these in a little more detail. But the one example I frequently give is, what do you do? Let's say you hire both Alicia and I, and you're going to pay 30. You want to pay $30 an hour for this position. Alicia, being a good negotiator, says, I want 30. And you say, sweet, it's exactly what we had planned to pay for this job. I come in and I say, 28. That's what I'm looking for. My current job pays this much. I just want $28 an hour. Well, Alicia and I have the same education. I went to Michigan State, which is so much better than where she went to Notre Dame, but that's beside the point. We have the same education. We have the same experience. We have all these same similarities, but I still want 28. Is that a concern under the law? Yes. It's a concern because we just use negotiation as a basis for a difference in pay. It is not one of the 6. So in essence, as we're going through these 6, and when we prepare our wage audit reports, which are required under the statute, one of the things I've been encouraging organizations to do is put which of these 6 matter on your job description. To identify these right from the beginning. Which of these 6 are we going to use to make distinctions in pay? How are we going to break that down? Which ones? Think about if you're a juror and you have one of these cases, how much more credible it looks if the company's able to say, well, we use seniority, merit, we don't use C, we also use education. How much more credible that looks when it's already identified in your job description, already identified in documents prepared prior to someone claiming that there's this difference. Yes?
How do you handle family members in closely held where you just want to pay the daughter more?
So, yeah, I will. So the question is, how do you handle family members where you just want to pay the daughter more? First of all, I always discourage working with family members, but that's a whole nother point. I'm kidding. That could be a problem. I just wanna is not one of the 6. So you need to identify the reason why I'm paying the daughter more is because the daughter has a different job. The daughter has more education. I did a performance review last year and the daughter scored 92 and the son scored 81. So I have a performance aspect I can fall back on, a merit system that's already in place. you just,
But if the company just wants to pay the children more, how should they do it?
under this law, that would be a problem. We can't just, these 6 are all we're allowed to distinguish. So if you had family member, for example, who's getting paid more than maybe not a son, but another employee, and you say, I just want to give the daughter more. If I'm a male employee doing the same job, I may say, hey, I got a problem here. You're making a distinction based on something that's not one of the 6. Now, there's another defense, but we won't go into that one now. But these are what it has to focus on. We're going to have to show that each factor is applied reasonably. That each factor, to the extent that there's a difference, accounts for the entire wage difference. And here's the key. This is mentioned all the time in the bill that's now a law. That prior wage history was not relied upon to justify disparity. What does that mean? That means in our job applications, we've already taken the conviction question out, or if you should take the conviction question out because that became the law back last September. We now have to take out that question, what were you earning in your previous position? In interviews, supervisors need to be instructed, don't ask questions like, oh, how much leave did ABC give you when you were there? What kind of sick leave does XYZ Inc. provide? Those questions can't be used. This was repeated over and over again in the bill. It's something you'll see come up in a lot of the slides. We cannot use anything previous to make distinctions. And why is that? Well, frankly, they were worried about continuation of basically continuing on discrimination. So in my organization, let's say Alicia gets paid more than I do. We both go to another organization. If my organization was basing its differences on the fact that Alicia's female and I'm male, then when we go to the next organization, when the next organization asks, well, what did you get paid in the last one? Then it becomes an issue because now they basically continued on the discrimination of our organization. So for that, they're very big on this, and you'll see this come up a number of times in the argument or in the slides. So what do we need to consider establishing? Well, we're going to have to walk through. Do we want a seniority system? Merit system? Do we want a system that measures earnings by quantity or quality of production, geography, education, or travel? Because these are it. So when we establish, when we're working through this, and when we're rewriting our job descriptions, and when we're working on our wage audit reports, which we'll talk about in a second, these are the factors we're using. So we'll have to think, do we want to establish one of these reports or differences? What's helpful with these things is the legislature really went to a lot of trouble and great degree to make sure all their terms were thoroughly and clearly defined. I am totally lying to you. They didn't define a single term in the bill. We have no idea what any of these mean. And what they did, they set up this law to be what they refer to as a living law, which will be established by courts and lawsuits and litigations, which of course is everyone's dream come true. Let's litigate what merit system means. So there's not much help from the legislature in terms of what they're looking at in each of these issues. My administrative assistant, she always reviews my stuff, and when she saw that slide, she's like, you forgot to put in the stuff. And I said, there was nothing to put in. So, seniority system. So we're gonna go through each of the 6. And these is basically your tying benefits to how long this individual was with you. Have they been with you a year? Have they been with you 2 years? Most of us have something like that in place already. It's a vacation policy. Most of us will have an accrual system based on if you've been here 0 to 1 year, you get this much. 1 year to 3 years, you'll get this much. That is a lawful discrimination. Don't knock discrimination. As I always say, don't knock discrimination. You can discriminate. You just have to do it lawfully. And in here, we're lawfully discriminating based on how long they've been with us, how long that individual is with us. So that would fall under the law. How does that work with pay? Well, maybe it goes as far as this. Maybe what we need to do is for each position, establish a chart that says from 1 to 3 years, this is how much they're going to earn, from 3 to 5, 5 to 7, and it works its way up the line. But we would have to do one of those we have to do one of those tables for every position we have. Every job description would be associated with the table. Yes?
Is it based on job position seniority within that group, or she started as an administrative assistant, worked that job for 2 years, and then became a vice president, which is a different role, and has just now started that?
Yes, so good question. And the first time someone asks a question which allows me to use my favorite answer of it depends, that always gets something. So I'm going to use my favorite it depends answer here. And the question was, when you're looking at seniority, what are we looking at it as? Is it with the company? Is it in that position? How do we do that? And I'm going to say it depends. Depends on what you want to do. You can establish it in terms of its seniority with the company. You can establish it in terms of its seniority within the position. But you'll want to establish that beforehand. So you can say, I've already got this in place and it's in the position, so that's why this vice president is earning less than the other vice presidents, because they've been in that vice president role less. So you can do that, but you'll want to be clear in your pay practices how that's broken down. Yes?
They've moved positions, so their pay changes, but their benefits don't, because they've been with the company long enough, they earn X number of days.
PTO, 401k.
Yes. Can you separate those, or do they have to stay with the job description of what they're doing at that?
So your question is, if I switch them jobs, can they move into a different accrual system for, let's say, paid leave? So our administrative assistants, they accrue leave at X. Our vice presidents accrue leave at Y. You could.
And it may depend somewhat on seniority, because if an individual is with you for a year, they get 1 week of vacation. But if they're with you 2+, they get 2 weeks. But that moves with
you. You could do that. You can have, even if you break it down to say our compensation is going to be based on how long you're in the position, you could flip it around to say, but our benefits will be based on the seniority as it's established in the vacation policy in the handbook. By the way, for those interested, we have I should have brought some, I didn't bring it. We have a free newsletter that we do. It comes out every quarter. I've been telling people, don't rewrite your vacation policy right now. There's a case, probably 2 cases coming out this year. We're involved in one of them that's going to the Supreme Court regarding how vacations accrued and paid out in termination. So hold off a little bit on vacation accrual changes. Yes?
So I'm just trying to get that straight on the seniority thing. So what you're saying is basically your job duties to establish, okay, say somebody works for you for 2 years, but they don't have as much experience as a guy you just hired. So maybe got 30 years experience in that same job. So you got to differentiate.
Yes. So the question was, so I'm basically pushing Clay because I got category number 1, which is going to take in his seniority with the group. But I also now going to look over at category 5, which is going to look at education, training, and experience before that person gets to the organization. Can I, mush those together? So it's also, I'm considering 1 and 5. Yes. But again, that's something you want to establish in that job description. It's something you're going to want to show in your wage audit report going forward. And that's when we see this all come together, we'll be in the wage audit reports that we're all going to be doing. Yay, spare time we all had to do those. What is merit system? Well, it's pretty much is going to go on performance. This is going to put a lot of pressure on supervisors. They are going to have to make sure that they're doing those performance reviews, that they're keeping track of reprimands or accolades or however it goes with that employee. Because if you're going to use merit, it will be too hard to define if you go, well, Michael just hasn't been doing a good job. I don't really know how to define. I never really gave him a reprimand, but Alicia's just better. That's a tough defense. So this is going to put a lot of pressure on supervisors, those who manage employees, to make sure they're looking at evaluations, to make sure they're getting all this together. And it all supports our decisions on pay differences. Merit system, any testing you use, if you're going to consider hiring a professional to develop targeted methods, basically you're going to we're going to analyze within the pay. We're going to get to that just in a couple seconds on the wage audit reports. Quantity or quality of production, this one really looks like a widget issue to me. They were very insistent that it be production, not performance. And so, is it possible to measure, we do X number of widgets, this person does X number of widgets a week, that person does less than that or more than that, and that's why they're paid differently. This very much looks like a production issue or maybe billable hours or those kind of things.
So,
Yes?
So this is a male-female issue, the way I understand it. So can we expect the next thing to be, we're gonna pay one male versus another male more than the other because we like one versus better than the other, and one female more than the other? Seems like that's the next step.
Well, that may be the question was, aren't we eventually going to get to, you didn't define it well enough why you paid this male more than that male or that female more than this female? Isn't it just going to be we like them better? Isn't that the next step? I think the next step is actually going to come this year. So I think yours may be the second step, but I think the next step, if you read the bill, they spend most of their bullet points talking about while there is a disparity in pay between sexes, there is even a larger disparity in pay between minority and non-minority status. And so I think there's going to be efforts maybe this year to get that involved as well, that they'll look at not only gender, sexual orientation issues, but they'll start to look at minority issues. And they'll bring those in as well. So we'll be also comparing that. Then I think we're going to get to someone claiming you're just paying me differently because you don't like me as much. Okay. Geographic location, how far is that? Is that Denver versus LA? Denver versus Colorado Springs? Is that second floor of Dalby Windland versus the third floor of Dalby Windland? How are we going to break that down? And that's going to be up to you. What we've said is when you're going to use that as a difference, make sure you have some support. If you say, well, the reason why we're paying Grand Junction employees more than Montrose or Delta employees is because the cost of living is less in Delta or Montrose or wherever it may be. You better have numbers that then back that up, because that's what it'll be. If it's just, well, we think it's more in Boulder, that may not be enough. So we want to make sure that when we're using geographic location, that we're breaking geographic location down and using the numbers as required. Education, training, experience. This is going to be those who come, well, I guess it's mostly going to be before employment with the organization, but certainly as they acquire credentials or experience, you can go higher. So this is the other way to look at it. And finally, the last one is travel, if you're using travel. So you want to document how far people are traveling and those requirements. Those are the 6. So all your pay differences from here forward have to be based on those 6, nothing else. And whatever basis must account for the entire difference in pay. Questions on those 6? Yes.
On the production. Say someone is producing several Excel reports that really don't apply to the organization. Do they get to be paid more than someone who produces one Excel report that does apply to the organization?
Oh, good question. So if you have someone who's producing like a dozen Excel spreadsheets, but they really have no connection to anything we're doing, but they just seem to be producing these, and we got one who's right on point, but there's only one. Can you say, well, this one is more important to us than the 12? Yes, you could, particularly because you'll be tying that back to your job description. So the job description will identify why that one is so much more important than the 12 the other one produced. So you'll want to always tie that duty back to the job description.
I have a question about that as well. On the quantity, is it hours as well, like part-time versus full-time? Can that be where a differential in pay is as well?
Ooh.
Is it time?
Time to give out a gift? I guess, sure. Because you're gonna stump me. I gotta think. I haven't heard that question. What? Could, I would think, oh yeah, the question was, could we base the pay on hours worked? I think, yeah. Sorry, folks on the web, I was just. I think if I were doing it based on that way, what I'd in essence do is probably differentiate it based upon the job description than using that category. So I'd have a TPS analyst 1 part-time and a TPS analyst 1 full-time. That way I'm breaking down. Now they do perform the same duties, but I think you could distinguish it in the job description as better than the production because they were really hung up on that word production. Was there a question?
Michael, we had a question from the chat.
Okay.
Connor asked, the Equal Pay Act is current law, not a bill, being considered by legislation?
The Equal Pay Act was passed May, let's just say May of 2019, goes into effect January 1 of 2021. It does have a 2-year statute of limitation, 3 years for damages. So we always get into this question of, are we in it now? Technically no, but I really encourage the organizations to start moving forward with it. Sorry.
Yeah, just to try to assess the threat or the risk of this. Are these 6 items and how we do your system? Are there going to be like auditors coming from the state periodically, or is it just all you have to give those turns
I like that question. So is this an audit from the state? Are you just a litigation issue? Yes, to both. So this bill, this now law, one of the interesting things it did, for those of you who've been through processes with the Equal Employment Opportunity Commission or Colorado Civil Rights Division, before you can walk into court to file a discrimination, harassment, or retaliation claim, you have to go through that administrative process. There's no way around it. If you don't, they throw you out. This law changed that. This law said you can walk right into court. You can file a litigation right away. You don't have to go through the administrative process. So it's much more streamlined. And it also could be filed with the state, so where you could see an audit based on that as well. So it's basically from a lot of different places. As we talked about, the bill also prohibits seeking wage history, relying on wage history, discriminating or retaliating against wage history. Just don't use wage history, is what these 2 pages say. Don't ask, don't look into it, don't bring it up. If they bring it up, say, yeah, I don't care. Nice, much more nicely than that. Other requirements. Here's, hopefully no one brought anything really sharp to throw, but here's one of the requirements is that we have to post as an organization internally on the same day every promotion possibility. Now I always get asked, what's a promotion possibility? And I always generally say that any job you have open is probably a promotion for somebody. So we have to post somewhere every time we have a job opening. We've been grooming Alicia to take over managing of the organization. She's been groomed for 5 years. This is her job, all set. Nope, have to first post it. Have to make sure it's available somewhere, yes.
Within the organization or even
We'll
externally?
get to externally in a second. But internally, yes, you have to post it somewhere. Is it on, and I've always said, well, what are you going to do with, those on leave, those who maybe satellite employees? Maybe think of creating a web page, which is identified in your handbook. If you want to look for jobs, here's where we're posting them. The next question I always get asked is, how long? How long does it have to stay on the posting? I don't think posting it during the Super Bowl is really going to count as posting and then taking it off right after. There has to be, I've been encouraging organizations, come up with a policy, come up with a practice. We post for 3 days. We post for this period of time.
Mike, we have a careers page on our website. Is that gonna, where our staff knows that that's where we post jobs? Is that gonna qualify as a?
I think that would qualify. I'd want to make sure it's in our handbook. I would probably add that all jobs are posted on this page. So it's on our sign book of the sign book sheet, sign off sheet of the handbook. Easy for you to say. Make sure employees know where they can get that information.
If you do that, is the web page sufficient, or does it have to be on location as well?
I would think it's sufficient because they only talk about posting. But the question was, is that sufficient to just post it on the web? I think that's going to be sufficient, but overkill is not a bad thing. The more you can say out there, like, this is one of the big requirements of the law is transparency, transparency, transparency. They want people knowing about job opportunities available, and so they want that information out. Getting it out, making sure, you want to be able to stand up and tell a judge or a jury, look, it's posted here. We send an email. It's above the time clock, or it's above we always post it right next to the donuts, and everybody grabs donuts. So we make sure it's available. Yes.
What if we kind of noticed that said job postings are always listed on Indeed, and then do employees have to see it before everyone else? Or?
No, they don't. The question is, do employees have to see it before everyone else? They don't have to see it before everyone else. It's an interesting question if you could just refer them to Indeed to meet that. I would probably, if I'm pretending I'm a juror, I would probably want something a little more employee focused as opposed to it's always in the Sentinel. That I would try to focus that. The other requirement that you have is you have to post the general description of all benefits offered, including salary range, must be in that posting. You're hiring for a CEO, you've got to post the CEO's salary range in there. You're hiring for a doctor, lawyer, accountant, whatever you're hiring for, that salary range needs to be posted in your job posting, and including a general description of benefits, 401k, vacation, things like that. Has to be in all postings.
Salary means total comp, right?
Salary could mean total comp, yes. Yeah. Well, I mean, you're looking at the total boat of compensation offered to the employee. That's what you want to make sure is identified in there. Yes?
So is this for any job posting that you put up in general or just for the employees?
Great question. I'm going to take the two external postings. You are not required to externally post. You don't have to post on Indeed. You don't have to post in the Sentinel under this law. There's no requirement to post. Once you do, you have to put this information in there. So if you're using Indeed, if you're using the Sentinel, if you're using LinkedIn, if you're using, I don't know what else people use, you have to post all this information in there. Has to be in there. My concern is individuals who are sitting at home making a cottage industry of just checking job postings on Indeed to see if they can bring some claim against some organization. So make sure you're posting your salary range. Yes?
I had an employee that was a previous employee, did a great job. They came back when I wasn't hiring and I made a position for them.
The question is, I had an employee who was really good before and they left. They came back. I really wanted to hire them because they're really good. So I'm going to hire them, right? Sure, as long as you make sure you first post this new job and identify the salary range for the new position and the benefits, and that others have the opportunity to see that posting so they can apply for that job. There's no, I've had a lot of organizations who are saying, well, we've been grooming this person for 6 months to take over the supervisor role, or 6 years. Yep, still needs to be posted.
That's not really what I meant.
Oh, okay.
I had an existing position that only had 2 people in it. I added a 3rd slot for that person just because I wanted them back in the company.
I would still post it. Basically, any opening I would post. Anytime there's an opening in the organization, I would look to post the job. Any creation of a new position, even if you got the position, because you want others who maybe weren't in that position. I understand that 2 others who may be in that position may not want it, but there may be others over here, under here, who say, well, I want that job. That is why we need to post. Yes?
How long the posting requirement is?
There's no requirement in the law for how long it has to be. That was the question, how long does it have to be? But you just got to look at it from the standpoint of, you're going to have to, hopefully not, but one day come into jury, we were meeting this requirement. We were posting. Look at we kept it up for 3 days. That was our policy. We told everybody 3 days, or we told everybody 5 days. Just want to make sure you're communicating that. Yes?
So we post through a temp agency. Do they then on our behalf have to post all of our compensation benefits for each position?
Yes, if they're posting externally. But also, the question was, we post through a temp agency. I would, even though you post through a temp agency, I would still post internally.
We will.
Okay. Yep. Any posting that you have out and about needs to have those issues in there. There you go.
So do you have to interview?
No, you don't have to interview them.
So you just have to post it and just say, I've decided, like in this case, I just decided this is who I wanted for the job. I don't have to interview anybody else.
You don't, the question is, if I post and I get 6 applicants, does that mean I have to look at interview 6 applicants? No, you can't say, well, I got the one I wanted, see a 5. I would still go through the other 5 to make sure that you've got the best candidate. But if you know someone's performance and you've worked with them before, that's obviously going to put them a lot ahead. Generally, sometimes it puts them a lot behind, but that's a whole nother point. Yes?
So in his scenario where you're creating a new position, hiring somebody, you're saying we have to post it. We only have to post it internally, right? We don't have to post it publicly.
You do not, there is no requirement. Yeah, the question is, if we're creating a new position, you only have to post it internally. There is no requirement to post it externally. It's just if you do, you have to make it look like what you do internally.
Michael, we have another question from online.
Okay.
Lori asks, what about inequalities in benefits and confidentiality of benefits?
What about any
Inequalities.
qualities?
Yeah, like inconsistencies in the benefits people are getting. So if there's differences in the benefits packages, and is there confidentiality associated with that, or
it's completely open. So the question is can we say, well, we're giving you these benefits as VP, but keep these quiet to just, don't tell anybody because everyone else will get mad. That needs to be posted if there's a difference in the benefits. It's what this law is really trying to do is transparency. So you have to always look at it from what is most transparent.
An odd question. It seems like we're in a period where you could have someone that was working for you that maybe wasn't very computer literate, and if they didn't know how to navigate the postings, could they claim that there was some kind of discrimination because they didn't know how to look at something on the computer? I mean, I know people that don't use computers, and it's not like everybody does this.
The question was, what if you have someone who isn't particularly computer literate, they don't use computers, and we just use computers? I would think much like, they've talked about making sure it's bilingual. If you have a Spanish-speaking workforce, and just posting it in English may not meet this requirement, I think you would have an argument If someone said, I don't even know how to turn the computer on, that, which would be, I wish I could go back to some days, but that would be an argument, and I would then want to post without using computers. Want to make sure this is your next chance over the next 11 months, 4 days, to figure out how can I get information to everybody. Because come January 1, 2021, we got to start doing this. Okay, it talks about we must keep copies of job descriptions, wage histories of each employee. This is basically the requirement for the job description. We then get into, this is the part I told you earlier, it allows the employee to file a claim right in court, but talks about some other things. I want to get to, there's a 2-year statute of limitations. There's an interesting issue in terms of what's our damages, what damages can a person claim. Well, if Alicia's paid $10,000 more than me, I would of course be claiming that I'm entitled to that $10,000. In addition, I can get attorney fees, interest, those kinds of issues. But they also can get, employees can also get what we refer to as liquidated damages. And basically what that means is if there's a $10,000 damage, I can get an additional $10,000 as what we refer to as liquidated damages. How can an organization, because in the law basically says, employee, you automatically get this additional money. If you can show there's a difference in pay, you get that loss and we'll double it for you. Seems to be an encouragement to file a lawsuit. How does an organization prevent that? Well, we have to show we acted in good faith. How do we do that? And I've got the language in there bolded, which is employer completes a thorough and comprehensive pay audit of its workforce. We have to do wage audit reports. It says every 2 years. I'm recommending every year. We look at every position. We identify each position. We have the employee name listed in there. We have the factors we're using to distinguish pay. And then we have the pay listed next to it. And we look to see whether or not we have any disparities. Look to see, why is this person getting paid? I just noticed it's $5,000 difference between the two. Well, we said it's based on merit. Yeah, but last year's performance reviews, they were the same. Well, it's based on experience. Yeah, one's been here 9, one's been here 9.5. Why is this pay? So organizations are basically required to go through to undertake one of these wage audits every 2 years. I'm recommending every year to make, and then correct any pay disparities they see.
Internally, and then, or we send those reports somewhere?
No, it's a good question. Internally, do we have to provide them to others? Just internally. And this is your year to do that, and you have the ability at the end to throw them away. Because we're not in the period yet. So next year is when we start having to keep these reports. So if you see pay disparities, this is your chance to correct those, to look at that, to make sure you're making any changes. You're not comparing yourself to your competitor. So there is no requirement to go out and say, well, we're at ABC Inc., but what is XYZ paying? Don't care. We only care what ABC is paying, and are we seeing any concerns?
So I apologize because I was a little late and I might have just missed this. In my very small company with 4 employees, we have very different positions, and right now I have kept one person with seniority at a little higher pay than another person. But that person's position as a bench jeweler is by far a higher pay scale than a sales associate. Is it okay if, regardless of seniority, if the bench jeweler?
Yes. So is it okay if I'm making pay differences based upon, I got one who's been here longer, but I also got one position I need more than the other? Yes, because at its core, you're basing that position on the differences in job description. Not, so you're almost comparing apples and oranges because you got a sales assistant and a TPS report manufacturer or something. Be careful when you're doing these, particularly yours was a small organization, but larger organizations, Don't just look to see like, well, what are all our engineers doing? Or what are all our managers doing? I've also been encouraging organizations to look to see employees that are within the same, near each other in terms of pay. Because how easy will it be for an employee to say, well, I know I'm supervisor over A unit here, and they're director over B unit here, but in essence, we do the same thing. Just because I'm supervisor and they're director, I have the same responsibilities. I have the same duties. Sure, they're over B and I'm over A, but that's minor. So when you're looking at it, also look at, for larger organizations, look at it to see which employees are really close to each other in terms of wages. You'll want to focus on those as well. So not just the same job description, but also same wages. Yes?
Part of this that goes, if you have an international organization, U.S. companies or international operations.
Yeah, that's a great question. Does it matter if we have these individuals in, for example, overseas, or we even got them in Utah? They got a job in Cisco. Do we need to show differences? If they're based out of the company here, I would still be doing the pay wage surveys with respect to them, but keep in mind that you have a big criteria you can use in terms of geography, one of those 6. So if you have pay differences, you can say, where these installers, they're paid X in Grand Junction, but because these installers go to New Zealand, we pay them, I'm making things up as I go along, we're going to pay them a little more. So you have that geography issue.
Does the pay audit have to be for Mason County? If what you're looking for your audit, if your employees are in Mason County?
I don't, what do you mean from Mason?
In my situation, there's not very many other people in Mason County that do what we do. And so we do a national audit.
Oh.
And I'm just curious to ask, does it need to be specific to?
You don't have to compare yourself to the county, to national. You're only looking internal. So you don't, when you're analyzing, am I paying under? If you're paying 10% under the market or 10% over, the law would say either way is great. We just want to make sure internally you're. Questions on that? We've covered pretty much all this stuff. You know, we must make reasonable efforts in terms of posting and those kind of things. But we have the information in your materials on job description and all that good stuff. Okay, questions on the Equal Pay Act? Yes.
Do we have to put this in our handbook?
Do we have to put this in our handbook, and do we have to notify employees of this new law? I would say that you don't have to say, this is what we're doing under the Equal Pay Act. I think any equal employment opportunity policy, any EEO discrimination would identify an equal pay issue and maybe even identify the Colorado Equal Pay Act as the basis for it. But in terms of, and we're doing wage audit reports, and you don't have to do that, but you should have something with respect to posting. So those issues would be added to your handbook, I would say. Questions? Okay, we're gonna do this one really quickly, simply because we don't know what it's gonna look like, but it's gonna look like something, which is in Colorado this year, they will propose a bill which will give all employees 12 weeks of paid leave for a serious health condition. It's going to look like, in essence, the Family Medical Leave Act on steroids. It is expanding out when the employee can take off, and it's expanding out who the employee can take off for. For example, under federal law, you could only take it off for yourself, your kids, your spouse, or your parent. This is expanding it out to anyone you're in a close personal relationship with. So you got that friend down the block who needs some help, that would be covered. It's going to be a paid leave, 12 weeks. Where's the money coming from? It's coming from all of our paychecks. They're going to have up to a 1%. They're going to start with a 1% deduction is going to look like what it's going to be. Will be deducted from all of our paychecks and then go into a big fund managed by the state. And then the state will dole it out as people get leave. Yes?
Is this every size of?
Every size of employer is what they wanted. Now, Governor Polis has said he's considering a 25 employee limit. I don't know how he makes where he gets the revenue enough to produce it if he gets rid of a large section of Colorado employers, but that's not, we'll see. Hasn't been proposed yet. The other thing to keep in mind with this, if it passes, under the FMLA, they have to work for you for a year. They have to work 1,250 hours in a year. This law, at least the way it was last year and the way they've talked about doing it this year, it will be you only have to work in the state for 650 hours. So if I'm applying to your organization and I'm on my first day, I can come in and say, hey, I'd like to take family medical leave under the state law. And you say, no, you can't, you just started. Yeah, but I've been working in the state of Colorado for 27 years or during this program. So because of that, I'm an eligible employee. So employees will be able to access this on their first day.
Where's the burden of proof on back to the employer to show me your salary stubs,
Yeah.
pay stubs to justify that?
That they haven't really figured out yet, but.
Well, as an employer, if you're losing somebody for 12 weeks in this program, are you required to keep their position open?
You're required to keep their position open or the same or equivalent position open. You don't have to keep it open, but when they come back, they've got to have a job. And the other thing for those of you who have 50 or more employees, you can't run this at the same time as the federal FMLA. So they get 12 weeks under this and then 12 weeks under federal FMLA. And you can't run vacation sick at the same time you're running this. Yes?
Is this just for employees working in Colorado?
Yes.
So our employees in other states does not.
The way, but again, we haven't seen the bill. We're going to see it this year. But it looks like it's just going to be for those working in Colorado.
For an organization that offers extended illness benefits for the employees, so if they're taking it off for themselves, it would be in addition to this?
Yes. So if you have EIB, if you have anything else, you're going to have this first, then maybe federal, then maybe EIB. I'm never working again. Yeah.
There's a question that the pay for the FMLA, for this FMLI leave, is it going to be full pay or is it going to be percentage?
It's going to be, I'm going to cheat if that person gets a thing. Yeah, the question is, how much are they getting? And I'm going to use my favorite attorney answer, it depends. The two plans we've seen are you'll get full wages if you make less than 90,000 or less, and then thereafter it's a percentage of your wages. The other plan we've seen is if you make less than 65,000, you get full wages, and then it's a percentage of things thereafter. So it's going to depend on what plan they put through. They say in their report that it's perfectly fine, and this will all work, and we have a sufficient number of revenue as long as no more than 3% of employees use it. Which makes sense to me, because if I'm funding my leave, I don't know why I'd want to use it.
Does it spell out how often this can be used?
12 weeks in a 1-year period.
Is calendar year or rolling?
You'll get to pick, but it's 12 weeks every year.
What if you have a temporary workforce? How do you bring somebody back in 12 weeks if you have seasonal work?
Yes. Oh, what if you do if you have a temporary workforce?
Yeah.
Yes, that's a problem. I mean, yes.
What about the owners of the company, like you're not covered under workman's comp, so would you be covered under something like that?
That's a good question. Will you be able to opt out of this like you can opt out of workers' comp? Perhaps. I'm not opting out of it. I'm taking my 12 weeks. Again, we don't know what this is going to look like. One of the main reasons I wanted to put this up here was keep track of this as the term goes on. I heard from senators and representatives across the way say it was amazing how many organizations we heard from. So if you support this or you don't support this, call, email, tell them what you think. Yes.
Those. They have health insurance and so forth that they have to pay a portion of. And if they got the 12 weeks of medical leave and they're getting the money from someplace else, who's going to pay their half of the?
They will. They'll still have to pay whatever their share is of that. Presuming what the bill is. Again, we're still waiting to see. Rhode Island has a similar bill, and 13% of the workforce uses it in Rhode Island. I'm not sure with our current unemployment rate what it is, where we're getting all these employees, but that's what's going to happen. So keep track of this. It hasn't been proposed yet, but there's just no question it's going to be proposed this year. Let's go over COMPS. This is a big change in how we deal with wage and hour issues in Colorado. So in Colorado, as a Colorado employer, we have to worry about the Fair Labor Standards Act. We have to worry about the Colorado Minimum Wage Order, which is the current law and is going to become COMPS. And then we look at the Colorado Wage Act. Those are the three that we have to worry about. This bill first came, but it's not a bill, it just came out as an administrative regulation, has gone through proposed rulemaking. The official publication of the proposed rule came out the Friday before Thanksgiving. I'm just sure it was just coincidence because I'm sure they thought we were all going to be around reading proposed rules during the Thanksgiving holidays, but that's when it came out. It is going into effect March 16th, except for the salary rules. Those go into effect July 1. So we've got about a little more than 6 weeks to get all these in place. What do we mean employee? Well, they're trying to, it basically means typical, the way we think of employees, individuals who are performing work for you, receiving compensation, those kind of things. But they're really focused on the gig economy. And as an example of that, Uber drivers. So this regulation really focuses on if that worker is doing something for your organization, which is your organization's purpose, they're going to look like an employee. So it really restricted who we can classify, or may restrict, who we can classify as an independent contractor. So for example, we're a law firm. If we hired an independent contractor lawyer, they may say, well, hold on a second. You're in law. Your lawyers should be employees. If you're in production, your production employees are those who perform work. So this may become more and more difficult to classify independent contractors as independent contractors because they're using this issue of do they do for you what your organization does? Basically the Uber drivers. That's what that's really been targeting. Time work basically means the same thing, but when we talk about basically what it's meant, which is basically, I love this definition, which is anytime the employee is permitted or suffers for the employer. Who doesn't love to think of work as suffering? That's the way they're defining it under the law. So anytime you've got an employee working, that employee needs to be compensated. We'll get to what those mean as we go along. So this could mean things like putting on or removing clothes, receiving or sharing work-related information, remaining on the place of employment, waiting a decision. So if they're just sitting around, like, are you going to assign me somewhere? What am I doing here? They're on the clock. They're getting paid. We have to do, that's the way they're looking at time work. Very broad standard. If an employee's waiting around, they're getting paid under this requirement. Employee continues, and then this is what we talked about. These are the independent contractors. Skip over that. Just want to do the independent contractor. The current order only covers 4 industries. So a lot of industries were specifically exempted. Retail and service were covered, food and beverage, commercial support, and health and medical. That was it. It was all the current order covers. The new order covers everybody. All organizations, everyone, not just in those 4. They decided to drop the 4 distinction, and now it's everybody except the state or any of its agencies or any of the political subdivisions or anyone who's under the state. I don't know why they picked those groups to exempt, but they're exempted from these requirements. Insurance industry, manufactured, I'm sorry, I'm on the wrong one. The current order specifically excludes these groups. So it used to exclude the insurance industries, the manufacturing, construction, community center boards. They were all specifically excluded. That has been dropped now. The new order says everyone's covered with the exception of these groups. So basically, we're covered, unless you're a government. This law, and we'll see a bunch of changes in this law, when we think about tech, I always ask, sorry, let me go from this standpoint. When I'm talking to organizations about wage issues, I'll often ask the question, is the employee exempt or is the employee non-exempt? And a lot of times I get the response back of, do you mean salary? If you look at wage issues, remember that salary is not the only requirement. To be exempt, to not have to worry about complying with the law, to not have to have all these issues, you have to prove that your employee meets 2 tests, a salary test and a duty test. Meeting one test is insufficient. You have to meet both tests. So when we're looking at our employees and we're trying to decide, do I have to pay this person overtime? Do they have to get rest periods? Do they have to meet these requirements? They don't if they're exempt under the law. They do if they're non-exempt. To be exempt, you have to meet the salary and the duty basis requirement. By far, the most publicity has been gained or about, most of the conversation has been about the salary basis test. They changed it from the proposed to this. So if you have the materials from the proposed, question.
And did you say that this doesn't apply to government or special districts excluded?
Yeah, so it would apply, I think, to private, but not to government. And so those folks who are from the government, you can just laugh at us as we finish the rest of the talk. I don't know. Be relieved. They set now currently under federal law, let's go back to this test here. To meet the salary basis test, currently under federal law, you have to pay the employee $684 a work week. If they're not paid $684, they cannot be exempt. They can be your CEO, they can be your CFO, they can be whatever. If they're not getting a salary of $684 a week, they cannot be exempt under current law. And what this law says is, yep, we're going to follow that as well. But this law also adds. So January 1 of 2021, we're going up to 40,000. 2022, we're going to 45. 23, we're going to 50. And 2024, we're going to 55. We're going to keep going up and up and up. So that means if you have an employee who's under 55,000 come January 1, 2024, doesn't matter what they do, they have to be, they're covered by all these issues. They talk, or when I actually testified at the hearing, and I encourage the Department of Labor to understand that they do not just represent the Front Range, they represent an entire state, and that they needed to look at that. They completely ignored that thought. And so basically, they set this up for Denver, and we're covered by it. There is an exception for this 2020 salary does not apply if you're a nonprofit employer with annual gross revenue of under 50 million, or you're a for-profit employer with annual gross revenue of under $1 million. So you may think, sweet, I get a reprieve. Well, except for the fact that this is current federal law. So there is no real reprieve because that date up there, or that amount up there of $35,568 is what's required under federal law. So it means if you're paying under that, that's a problem under federal law, although state may exempt you to the end of the year.
Does the federal law have
steps also?
No, federal law stops at 35,568. So they're done after this year. We keep going up. Yes.
You're talking total compensation there, right? Everything.
Nope, I'm only talking, the question is, am I talking total compensation or salary? I'm only talking salary. Federal law has this thing about catch-up payments and payments at the end of the year if it turns out you're under and those kind of things, but state law doesn't have those. So it's got to be salary. Yes.
Well, we have, a lot of our employees are paid in different ways. Like we have some that are commissioned, strictly commissioned.
I'm concerned. The question is, what do we do with those commission employees? Certain commission employees may be exempt if they perform certain duties. We'll get to those commission employees. They may be exempt from that, which they'd be okay. But those who are paid fluctuating amounts based on other things besides commission, that could be a problem. So there's a little handy chart to see how they're all growing up and then going up. And then after 2024, it's going to go up on a CPI index. And so they're going to keep going up. Under federal law, we have these exemptions, and there are a ton of them. I mean, I always tell the story. It's amazing the number of exemptions. I mean, yes, we have administrative, executive, professional, all those issues. We have my favorite exemption for the Christmas tree wreath maker. If your organization makes Christmas tree wreaths, not garland, it's going to be the wreath. And if you make them out of natural evergreens, not pine cones, I mean, those are nice too, but it's got to be natural evergreens. And if you make them out of your home office, so if you make Christmas tree wreaths out of natural evergreens in your home office, you meet one of the exemptions under federal law. Anybody do that? Know someone who does that? Still waiting. There are a lot of exemptions under federal law. We have gotten rid of most of them under state law. We have very few exemptions now under state law, and that's what we're going to focus on next. I just listed all the better ones. So we have, we're going to go over the exemptions, which are administrative, executive, supervisors, executives and supervisors, professionals, outside sales. The federal law looks at what is the person's primary duty and do they have a lot of management, independent discretion, and judgment. If you want to classify, for example, your CFO who doesn't maybe supervise a lot of individuals, under federal law, you have to show that that person is doing a lot of non-manual work, really significant decisions, and making those decisions with a lot of independent discretion and judgment. COMPS is a little different, and it's causing a little concern. And they've set up the law to say you have to, of course, meet the salary basis. It says in the requirement that the person must directly serve the executive and regularly performs duties important to the decision making. Directly serve the executive and has decision-making authority. It is not defined in COMPS what it means to, what executive means. And then they must also regularly exercise independent judgment and discretion on matters of significance. The concern that has come out since this has been released is, what does it mean to directly serve the executive? I even put up, how do we define the term "the"? Because, for example, if you have, I don't know, your HR director reporting to someone who is not the CEO, is that person meeting this exemption? Because do they directly serve the executive? That's what the requirement is. It has to directly serve the executive. So there could be an argument that unless you report to the CEO, you cannot meet the administrative test. So I think CEOs are going to be having a lot more people reporting to them coming up. No, I'm joking. But that's what our requirement is under this new state regulation, is we're looking, do they directly serve the CEO or president? I think there could be an argument as to that. So for example, I have an organizational chart If you look down at the foreman, those individuals are not directly serving the executive. Now, there's an argument that will get undoubtedly litigated as to whether or not, well, they report to the manager, and that manager is an executive. I can see that argument. The problem is that manager is an executive, which means multiple, not the executive, which tends to mean singular. So when you're looking at whether or not your employees can meet this test, one of the considerations is going to be, who do they report to? Do they report to someone besides the president, someone besides the CEO, someone besides that individual? So that's one exemption. Any questions on that one? Okay. Then we're going to get to the federal exemption, the executive exemption. And this we frequently have worked with in terms of, do they supervise 2 or more full-time employees, and do they do that as their primary duty? Not a time clock standard so much under federal law. It's more of, why did you hire this person? What is their primary duty? So I always use the example, think of firemen. What's a fireman's primary duty? Fighting fires. What do they not spend the majority of their time doing, thankfully for all of us? Fighting fires. But it's still their primary duty. So we're looking under federal law as to what the individual is primarily doing. Are they primarily involved in supervision? State law changed that, or is changing that. We have to meet the salary test again. They have to supervise the work of 2 full-time employees. They have to have the authority to hire, fire, or to effectively recommend such action. And they must spend a minimum of 50% of their work week in duties directly related to supervision. They have to spend 20 to 25 hours a week directly in duties related to supervision to meet this exemption. So looking at, it's no longer primary duty. We're now actually going to focus a lot on time clock standards. How much time is this person working in those duties? The really good thing is that, and I pointed this out when I testified as well, the term supervision is not in the law. They didn't define it. Federal law defines it, so I think we're going to fall back on federal law, but it goes into, federal law defines management, interviewing, setting, adjusting rates of pay, directing the work of employees, maintaining direct sales records. These are what equals management under federal law, and what I think will be under state law as well. So you have to have an employee spending 20 or 25 hours a week to meet this exemption. And if they don't do 20 to 25 hours, they're not going to be able to be exempt under the requirements. Questions on that? Okay. We're going to go to the requirements in a couple seconds, but I wanted to go over the exemptions. The federal law with respect to professional exemption is basically the same thing, which is you have an individual who has an advanced degree in science or learning, and that advanced degree is required for the job. If you've got, let's say, 5 engineers, and Mary has been with your organization for 30 years, she knows more than every new engineer coming out. She's got this down. She doesn't have the degree, but she's been doing it 30 years, and she's forgotten more than any of those folks know. That position will not be exempt under the law because you have an employee who's doing the position without the degree. So that degree has to be required for the job, or they can't meet the professional exemption. So you're looking at doctors, lawyers, CPAs, registered nurses. Those individuals, they can perform, they would meet the professional exemption. Just a quick hypothetical I had as I was going through the changes. So you got Jane, who's been with you for a long time. She started as a registered nurse, and of course we classified her as exempt because registered nurses are exempt because she's doing exempt duties and it requires an advanced degree. We've decided to promote Jane to manager of the department. She oversees a lot of critical work in the organization and reports to the chief nursing officer, but doesn't really do those nursing duties anymore, isn't performing registered nurse duties. You could do the position without the degree. It's not as good maybe, but you could. And she doesn't do a lot of supervision those day to day. Is she exempt? There's an argument now that she's not, because she's no longer professional, and now she's not meeting the executive exemption because she's not supervising enough. She's not administrative because she doesn't report to the CEO. So be careful when you're doing those exemptions, when you're working, on those job descriptions. Be careful that you're looking at these. Outside sales exemption, we talked about these. These also look at that commission. These have no references to any pay requirement for the exemption. So if you have an outside sales, there is no requirement that they get certain amount of money. Other comps exemption, owners are exempt sometimes. Interstate transportation workers are exempt, taxi cab drivers. For the extent we're worried about paying our casual babysitter $35,000 a year, they're exempt. Property managers, student resident workers, laundry workers. I have no idea how you came up with some of these. Obviously, bona fide volunteers, interns are exempt from these requirements if they meet these requirements. Agricultural workers, they also changed that in the recent law or regulation as well. If you have computer professional folks, they're exempted from this as well. So those are, when you're looking at, do I have to comply with this with respect to my employees? What we're looking at is, are they exempt or non-exempt? This is where we make that determination. Certain salespeople and mechanics, commission sales, those employees of retail, a number of ski industry is always exempt. Medical transport. Medical transport is interesting because they were covered under a previous version of the order back in 1997, and then they threatened to sue, and suddenly we came out with a new order on the state saying, nope, sorry, didn't mean to cover medical transport, and so they exempted them, and they've kept that exemption. 880 rule for nurses. Those are the exemptions. As I said, we don't really get to use federal exemptions anymore. We're focused just on the state. Yes?
I was reading on your COMPS exemption. Excuse me. Exemptions, certain salespersons and mechanics, but then it defines it as retail dealers.
Yeah. I was surprised with that as well. I mean, that's what they limited to, just those organizations.
Are teachers exempt?
Teachers are exempt. Because there should be public. So things like fluctuating work week, those are no longer. So that ability to pay the employee half-time after 40 hours, those are gone. Someone asked, is it all compensation or is it just salary? They don't mention anything about additional compensation, additional bonuses. That's permitted under federal law, but not under state. Yes, those are the federal stuff. Okay, question.
So then, like construction foremen, they're not exempt. They have to pay hourly.
Construction foreman would be an interesting one. They're not going to meet the administrative exemption, certainly because they're doing manual work sometimes. Administrative would require non-manual work. The construction foreman position is going to depend on how much time they're spending being the foreman and how much time they're out there digging ditches and putting up walls, wiring, those kind of things with other employees. If they're spending a majority of their time doing the construction work, they're not going to meet the executive exemption. They've got to spend the majority of their time supervising, not doing the work. So yeah, construction foreman under this new, makes them look like they're going to be more non-exempt than before.
For professional exemption, are they considering like a CPA certification, that higher education, or are they only looking for the higher education?
Certified CPAs would be exempt under the law, but it has to be a requirement of the position. So for example, if you have a CFO, do you have to have a CPA certification to be exempt as CFO? There's an argument that maybe you don't. Maybe the job can be done without the certification. So we want, if you're going to use certifications, you've got to make sure you have a basis to say, this is why that certification is required. Regular rate of pay, this just goes into when we figure out the overtime rate, what the individual is their regular rate of pay. It's all compensation paid. So any non-discretionary bonuses must be included in regular rate of pay. If you give someone a $50, hey, way to go at the end of the work week, that must be in their regular rate of pay. If you give someone a, you've been working really hard and you met your sales quota this year, that has to be included in regular rate of pay. It's not just what you call the hourly amount. It tends to be all things included. Not holiday bonuses. Everyone always asks me, what about holiday bonuses? But basically anything like business expenses, those can be excluded. Bona fide gifts, discretionary bonuses, investment compensation, vacation pay, those can be excluded. Anything else needs to be included. Yes?
So basically, spiffs would be considered rate of pay.
What?
Regular pay, a spiff.
A spiff? I don't know what a spiff is. Oh, bonus.
Well, a spiff is like, a spiff to me is more like, I'll put spiffs on certain pieces we sell. If you sell this diamond, there's a $50.
That would, yes. That would in essence be a non-discretionary bonus. Now we get into whether or not that falls under one or the other one, but I would be concerned when you tell employee, you do X, we'll give you an increased amount, that amount would then need to be included when you're determining what their overtime payments are. They're really trying to get everything into regular rate so they can raise the overtime rate, which gives them more withholdings. Did I say that out loud?
Mike, we've got an online question.
Oh, online question.
Sandy Browner asks, so requirement for a 4-year degree or 4-year accounting degree would not be considered an option in making the salary position non-exempt?
A 4-year general undergrad accounting degree would not, in my opinion, be exempt under the law. You need to meet that higher degree, that master's, that certification, something else that they do to make that person exempt. They may meet the administrative, but they're not going to meet probably the professional. Same with engineers. Is the argument. So there are a bunch of crazy, the wage and hour law is the most confusing law, I think, in employment law. There's so many persnickety little things in here. And by far, the most confusing aspect of it is the travel pay. There are issues under federal law in terms of, is it all in a day's work? Is it a one-time assignment? Is it overnight? Are they going to be a passenger? Are they going to be the driver? Are they using our cars? Are they using their cars? There's all these rules under federal law. We're under state law now. And so we have a new definition of travel under state law. So when you're thinking about, do I need to pay this employee travel? Basically, it starts with the premise that if they're traveling for your organization, they're getting paid. If they're doesn't matter if they're transporting, if they're going from A to B after their shift, during their shift, on the weekends, as a passenger, they're asleep in the back. If they're traveling for you, it's going to start with the premise of they have to get paid for that time.
What about their home office bases in Frisco, but today they have to work in Vail? They're scheduled to work in Vail, and they're scheduled to work somewhere else.
So if they have a home office based in Frisco or Vail or whatever, and then they need to go to the other office today, you'd want to make sure home to work travel is never covered. So what you'd want to make sure is that that person understands that work is defined as the Vail place, the Frisco place, so that you're clear that now if you put our Durango office, well, when was the last time you went to Durango? Never. Then there's really not a duty. So you want to make sure you're focused on just those things they have to do. Yes?
So if
meet at a location, they get in the vehicle, we have to pay the passengers now?
Yes.
And the driver?
Yes.
Is that in all states?
No. Just ours.
You repeat the question.
Sure. The question was, what if they're, now we're going to get to a couple exceptions, so don't hold that thought. A couple qualifiers on that. But the question was, if they don't meet any of these issues up here, and they all meet at the Burger King, and then they all drive from the Burger King to, that would be considered work time, to the work site. That would be considered work time, unless they meet these. Now, they gave us a couple of exceptions. Travel to and from the workstation entirely within the employee's premises shall not be considered time work. So if they're within the premises and they're driving around, that is not. Where is it, Chris? Where I want to, an employer's mandated transportation that, so if you say you've got to drive this skid steer from our location over to here, and because that skid steer doesn't move as quickly as another vehicle, that would be considered time worked. So it would have to be compensated as well. Or they said if it increases the time or increases the risk, which seemed like a workers' comp issue to me, but go ahead.
Couple questions came in. What about traveling for training or pursuing education, and do agriculture-related industries still have exemptions for overtime?
Agriculture industry, we're lumped in. Make sure you're looking back, the agricultural question, look back at the exact definition in COMPS. Agriculture did get a few exemptions in this version of COMPS, which helped. If they're traveling to training, they're working and the organization's required them to do that training, or it's required as part of their job, they're getting compensated for that time. It's work time. So don't forget, you don't have to pay them at their regular rate. You have a registered nurse you pay $40 an hour to. That person is traveling over to Denver. You don't necessarily have to pay them at $40 an hour. You only have to pay them at the minimum wage. So you can move travel down to what is currently $12 an hour. Yes.
So if corporate office is in Grand Junction, we have a branch in Delta. They all come to the corporate office, they get in a vehicle, and they drive to Delta. Do we have to pay them?
I would say if you're requiring them to show up in Junction, the question is, hey, we got a corporate office. We want everybody back in the corporate office. They're going to then go from the corporate office to Delta, that time in the car because you required them.
What if we don't require them though? It's just their option to carpool there.
Yeah, if they're doing it voluntarily outside of the organization, I think you would have an argument if you could make sure that Delta is considered their work location. Because, for example, if they don't go to Delta very much, maybe Delta is not their work location. So it really expands out travel time. We're going to have to pay a lot more travel time for non-exempt employees. Oh, and then they don't cover doctors, lawyers, and teachers. There's a reduced minimum wage. Don't forget, employees under this law, we've always talked about under the federal law, we only need to pay overtime when it's 40 in a work week, not under state law. State law, we have 12 in a day or 12 consecutive hours. So anytime an employee is now working over 40 in a work week or 12 in a day, they've got to get overtime. If they work, let's say 15 hours in a day, but 43 hours in the week, you only need to pay them 3 hours of overtime. They don't get to double dip that because they had 3 hours extra on the 40, 3 hours extra on the 12. That would only be 3 hours overtime. They don't get 6. Yes.
What if your job, your agreement says it's only over 40 hours, it doesn't specify over 12 hours a day?
If you have a contract with like a GC that says we're only paying overtime, that's all we can get payment for. No, that would not be an exemption, I would say. Union shops do get a break on the rest. Oh, the question is, what if we're a union shop and our union only says over 40? I would be concerned that's inconsistent with state law. You're in essence trying to contract around law, which generally they don't like. Yes?
So back to travel time question on, say, a travel scenario. you have an employee that.
You do know I hate travel time questions the most, right? No, I'm kidding. John knows that.
It's a test. So
yeah.
Say we leave, have an employee leaves here at 3 o'clock.
Traveling 60 miles an hour.
Flies to Salt Lake. Gets in at 7 p.m. And then spends the night, and training begins the next day. So it used to be that you just compensate them during regular working hours.
Anything that cuts across the normal workday, yes. That's still the case, but that's only the case under federal law. Now travel is anything for the organization. So if they're traveling to Salt Lake from 3 to 7, they're getting compensated. They used to only get compensated from 3 to 5. Now they're getting compensated from 3 to 7 because we've dropped that hole in during their normal work hours.
But not for the overnight.
No, they still wouldn't get paid for you don't have to pay them for sleeping at the hotel unless, I guess, there's some work duty they're doing while sleeping. Could happen.
Question from Serena. If we are a Colorado-based employer with all employees working in other states, will we pay for employees' travel between states?
The question is, what do we do with employees who are traveling in other jurisdictions? The law has a really crazy thing on it where it basically says you have to do whatever's better for the employee. So we'll get to an issue where the employee is traveling from Junction to Denver, and you've set the rate at $12 an hour, but Denver, of course, didn't Denver go to 15? Or they're talking about going to 15. If Denver goes to 15, once they get into the 15 jurisdiction, now they're on 15 instead of 12.
So if they go to Utah, they can go back down to 10?
No. Always have to do what's most beneficial for the employee, but I like the way you're thinking.
So on the question that John had with the travel time, what if that goes into overtime and you did the $12 an hour for the travel, then now all of a sudden they're overtime?
What do you do if you're using a different pay rate and now you're in the overtime? You do what we call a blended rate, which is you're blending the hours, so you're multiplying $12 an hour times 5 hours they drove, $40 an hour, or I'm sorry, 40 hours times 20 hours they worked. Let's do that again. $12 an hour for 10 hours that they drove, $20 an hour for 40 hours that they worked. So then you multiply those out, that comes out to 920. Then you divide 920 by 50. That's the number of hours they worked. So you figure out what that is. That's their blended rate. And then from there, you pay that halftime because you've already paid the time of that time. If everybody got that, or if I'm even close on my math, where are the CPAs? Who tell me, was I close on my math? Did okay? Okay. I can't, yes. You can ask as many questions before we get to this next section as you can find, because I do not want to go into the next area of this talk. Because people are going to be mad at me. I didn't write it.
Do the employees get paid overtime for standby time? Not actually working, but on call?
So it's going to depend on how much, the question is, yes, with on call, when do we need to count that as when do we need to count that as time worked? It's going to depend on a number of factors when you have an on-call employee. It's going to look at how many times are they actually called. If they're getting called 3-4 times a night, that looks a little bit like they're working. If when they get called, they've got to be somewhere in 10 minutes, that looks like a lot of working. If they have to perform emergent duties, if they have to be in uniform, it looks like they're actually working, because those significant requirements are now restricting what their normal life is. Basically, the way you call on-call time, not work time, is you basically allow them to live their life. They want to go hiking on the monument, they go hiking on the monument. They want to go to a movie, they go to a movie. Just get back to this person within some reasonable amount of time, all good. There's a tree, if you don't answer it, the next person will or someone will. all good. Don't ask me why, but the first thing that every court decision I've ever seen, well, second thing, they always go over number of calls per day or per week. That's number one. The number two issue they look at, does the employee get to drink while they're on call? I swear that judges think we all go home and just start drinking. Maybe that's what judges do, but that's what the law always looks at. The cases always go over, can Michael drink the moment he's on call? If you can, it looks like that's normal life, I guess, to a judge. If, on the other hand, you can't, that looks like you're restricting them from what they normally do. So that's what the case is. Yes? So automotive service rider, would they be considered salespeople? I wouldn't think so. Again, this only came out 5 days ago, so we're still waiting to see, but I wouldn't think they would. Federal law has worked a lot with that, but state law kind of glossed over it. Yep, they have. Any other questions, please? Okay, I'm not going to get around it. So a couple of the big issues that have come up with respect to this law are the meal and rest periods. They don't really change it much unless you call 180 degrees completely changed. It's still the same law, which is that a non-exempt employee has to, gotta receive a 30-minute, at least a 30-minute, unworked, uninterrupted. You don't have to pay them, but anytime they work over 5 hours, they have to get a 30-minute lunch period. Gotta, have to. It's a violation of the law, in essence, if they don't. So, extent practical shall be at least 1 hour after the start, because we used to say, a lot of employers say, we give the lunch period right at the end of the day. And the state said, no, you can't do that. It should be at least 1 hour after they start and at least 1 hour before the end of the day. They must be completely relieved of all duties. So if they're sitting around and they have the chance to get called back, that does not meet this requirement. If they may have to pick up the call for a customer, if they may have to do something, it does not meet that requirement and they have to be paid for that time. So, exemptions?
Are there any exemptions?
Oh, no. Unless you're an exempt employee, no, there's no exemptions.
What if they choose not to do that?
Yeah, so, if they choose not to do it, we're going to get into an interesting issue with the rest period and we'll cover that. Let's hold off 2 seconds on that question.
So we're, like I said, a very small company. The company provides lunch for all employees and they voluntarily don't want the time off in the day.
Yep. Because they want to get out early. They want to. The question is, hey, these employees want to work through lunch because then they're not here till 6 o'clock, 6:30 at night. They get to leave a little earlier. Hold on to that question 2 seconds because we're going to get to rest periods and it may, we'll get to where the law kind of goes crazy. Let's talk about rest periods. This talks about if it makes it impractical, the employee shall be permitted to consume an on-duty meal period while performing duties. Before you guys think, whew, that is exactly what I wanted to hear. Hold on to that thought because the rest periods goes, as I said, goes a different way. Okay, rest periods. Basically, this is, you have to give an employee rest period. 10 minutes, you'll see if they work 2 or fewer hours, they don't have to get it, but a 2 to 6, it's 1, 6 to 10, it's 2, blah, blah, blah. They've have to get a rest period that meets these requirements. They have to be authorized, they have to be permitted to take rest period that meet these requirements. What does it say? I don't know who's going to use this, but they were all excited with this idea that you don't have to do it 10 minutes. is if you come up with an agreement with your employee that is signed by the employee, that instead of 1 10-minute break, it'll be 2 5-minute breaks. That'll make it so much easier to figure out. But as long as they can get back and forth to the bathroom in that 5 minutes. You're not required to meet the requirement for rest periods if you're governed by a collective bargaining agreement or if you receive Medicaid funding. So if anyone out there meets either of those two, you do have exceptions to the rest period. So the question is, any rest period exceptions? These are the only two. And then we got those kind of things. Where do I want to get to? Okay, here's the confusing part about, or here's what they did that kind of made this all confusing. And this is based on a case that came up about 2 to 3 years ago, which is in that case, the employees took the position of, hey, I'm not getting a rest period. They're making me work through it. And the organization said, yes, but the law permits us to give you a rest period insofar as practicable, which is actually what it said in the law. And the employee said, yes, but the problem is when I work through rest periods, I'm in essence extending my day by an additional 10 minutes if I'm entitled to 1, or 20 minutes if I'm entitled to 2. So you've in essence made my 8-hour day 8 hours and 20 minutes, even though I only worked 8 hours because I was only supposed to work 7 hours and 40 minutes, but you made me work 8 hours. Everybody get that math? So the employees were claiming, I was only supposed to work 7 hours and 40 minutes. You made me work 8. That's an additional amount of pay. And the employer said, well, what's the problem then? We pay you for the rest periods. And this court said, yeah, we don't think that meets with the law. So employer, you have to add 20 minutes on to that employee's compensation at the end of a day when they don't get their 2 rest periods. That's what the court said, and the Department of Labor followed up on that requirement, basically saying if an employee doesn't get their rest periods, the proposed version said when an employee does not have a required rest period, you have to add 10 minutes of compensation on at the end of the day. How are we going to prove that the employee got their rest periods? Ask the employee during the litigation? May not get the most employer-friendly response. How were we going to do that? One argument under the proposed is we were going to have to start having employees clock out for rest periods, for paid rest periods, because we needed to show that they got the rest period. The new law, whoops, where'd it go? Sorry. Did I lose a slide somewhere in the whole thing? I may have.
Can we get rid of that law then?
Can we get, once the law's gone. Yep, it's all good. You're all fine. I actually had a dream that I was at doing a talk, and someone asked me a question that required me to pull out COMPS, and I could not find my version of it. So it's so exciting to me that that did not come to fruition. The new law, where this says, the proposed regulation, sorry this isn't in there, but you'll want to write this down. The old one says when an employee does not have a required 10-minute rest period. The new one is when an employee is not authorized and permitted a required 10-minute rest period, then you have to pay them an additional 10 minutes at the end of the day. That is key language in the law, which is, are they authorized and permitted? Where are they going to be authorized? Handbooks, supervisors. Making sure that they're authorized and permitted. Yes?
Time that's supposed to be break, we have a buzzer goes off that tells the employee.
Oh, sweet.
This is your break time.
Yep. So,
you need to go. And then we have a buzzer that tells them it's time to come back.
yep. For buzzers, those kind of things, that'll work really well for rest periods. Those of us who don't, It's a little harder to say, look, Michael was looking at Instagram for 10 minutes. That shouldn't count. The problem is sometimes he checks his fantasy football while he's on the phone. So what you really want to do, be very careful. You want to make sure employees are aware that they are authorized and permitted. We want nothing, no supervisor statement, no anything that is inconsistent with that, because if it is inconsistent, employees can go back and say, you owe me 100 minutes for every week, 5 days, 20 minutes a day. You owe me 100 minutes of compensation because I was never authorized or permitted to take a break. And the concern with lunches, we were talking about lunches, I could see someone making an argument of, hey, because I worked through lunch, you were in essence extending my day by 30 minutes, just like you were under this rest period. So I could see another case coming out concerning lunch periods that looks and walks and talks just like the rest period one. Yeah.
Jill asks, are employees of agricultural businesses exempt from overtime?
Yeah, for agriculture, it depends on the agriculture. Make sure you're looking in, it's in the materials that we go back, but there is an agricultural exemption in that requirement. Yes?
So if the definition of authorized is in the handbook, or the supervisor tells you that, what is the definition of permitted?
Yeah, it's good question. I'm going to use the question is, if you say authorized and permitted, what is the definition of permitted? I would look at it, I don't think under the new rule that we're required to show that the employee punched out. But you're going to want to have a handbook sign-off sheet that identifies you are authorized and permitted to take a break. If anyone gives you any guff, if anyone tells you you're not permitted, you come report to us. If you ever feel any retaliation because you took a break, you report to us. You'll want to make sure it's clear that they are authorized and permitted on those breaks, because it's too easy for an employee just to turn around and say, my supervisor really never let me take those breaks.
But aren't lunch hours different? Because if you're over 30 minutes in a lunch hour, you don't get paid as an employee. So if you work through that lunch, you're getting paid as an employee.
No, my argument with rest periods is that what's the one thing that is no more true ever since 1939 with respect to non-exempt employees? Non-exempt employees are only required to be paid when they work. That's the law. You don't have a non-exempt employee doesn't work, you don't have to pay them. This law says, no, you do. You have to pay the non-exempt employees for 8 hours and 20 minutes, even though they worked 8 hours, because you didn't give them their break. So in essence, they're making us.
Well, that's the break.
No, I'm agreeing with, you and I are on the same page. And I would say rest periods, they can't do this, but they did. And I'm concerned that someone's going to try the same thing with lunch periods. Now, there's an argument as well that, look, we're still paying them for their work time. You can't go beyond that. That's the argument. It's just a concern that's out there.
Is the compensation for providing lunch, we let them, everybody just kind of rotates and picks what they'd like for lunch. Is there any?
Ooh, offset of meal credit? You could, the question is, could we offset the meal amount? You could if they were a minimum wage employee and you were looking to take that credit against minimum wage. You couldn't, anyone over minimum wage, you wouldn't get a meal. I know, time, I got one last question. I'm going to stick around for questions because we ran a little short. The one thing other to keep track of is you have to post, and this has to be in your handbook. So if you have a handbook, we have to post COMPS. We have to put it in our handbook. We have to make sure that it's being distributed to every employee. What it says here is every employer that requires employees to sign any handbook, manual policy, at the same time, promptly thereafter include a copy of COMPS poster published by the division. So they're going to publish the poster. They got like 6 weeks. But that poster needs to be in your handbook to make sure employees are aware of their rights under COMPS. The rest of this stuff is pretty just litigation stuff. I'm going to skip around that. Any questions, please come up afterwards. I want to make sure I don't go over too much. Thank you for the opportunity this morning to present to the group and for all the great questions. I really appreciate it. Thank you.